So my name is Melba Katindi, and I'm an advocate of the High Court of Kenya. I work with an organization called KELIN, and KELIN is a human rights organization that advances human rights in the health sector. Mostly our areas of focus is HIV and HIV-related rights, which brings in TB and cancers within the health sector.
My name is David Musyoki. I work for KEPCA as a programs officer, a nurse by profession, and been really very interested in this program, so I've been the one running the legal aspects program with different hospices. Welcome.
My name is Johnson Rido, working with Nyeri Hospice as a social worker and also a trained paralegal.
I'm Masiowiti, a palliative care nurse working with Nyeri Hospice. I have a lot of experience in palliative care. I'm also a trained paralegal working with patients with life-limiting illnesses.
Good afternoon. Robert Kimunya is my name. I'm an advocate of the High Court of Kenya. I'm also based in Nyeri. I'm a friend of Nyeri Hospice. And by and large, therefore, I've become interested in KEPCA issue.
I want to begin by just mentioning that the two main articles that have prompted the work that we do around integrating legal issues are two. We have Article 43.1 of the Constitution of Kenya 2010 recognizes the highest attainable standard of health for all. So this means that we must then look at issues of quality, we must look at issues of acceptability of the service that we are providing, we must look at the issues of accessibility, we must look at the issues of availability. So we are moving from the old constitution that basically left the individual to cater for their own rights to now a constitution that declares it or guarantees it as a human right, though how progressive should it be? But we must understand that now issues of quality of healthcare provision come to light when we are providing the services that we are providing. And our argument is that if you look at Article 43.1 and tie it with the provisions of Article 48 that are talking about issues of access to justice, then it means that the service that we are providing must incorporate a system where we can have complaints, mechanisms, resolutions, and that also entails facilitating easier, affordable, more accessible services for those in need and those most vulnerable. And we're arguing that those who are facing life-limiting illnesses are most vulnerable amongst us in terms of their susceptibility to human rights violations. So on that note then, I would like to have our first speaker who's going to basically introduce us to the issues by presenting us with an experience of herself as a healthcare worker. What are some of the challenges that she has faced that she feels that legal services integrated into the work that she does will be able to address?
Working with Nyeri Hospice as a nurse, palliative care nurse, stroke paralegal. This knowledge on legal issues, it didn't just come like that from nowhere. We got basic training from a lawyer who by then was working with KEPCA. And after the training, before that we felt there was a need for patients to be managed holistically. Because when we leave outside certain things like legal issues in palliative care, and anytime you take care of a patient and you say the patient rest in peace, those patients have not rested in peace. Because when they leave their family suffering with unfinished business, like maybe people are grumbling over property, they are not in peace. Although they are gone, although they are still alive, it is not very easy. The basic training we got, before I used to do it, we used to do it, but it was not complete without the knowledge and skills that we got from the training we got us. That is around 4 years ago. So Nyeri Hospice implemented integrated legal issues into our services back in 2011 January. And from that time we have been working with Advocate Robert. There were others who left, but Robert has stood with us up to now, is still taking care of that part of legal issues together with us. So there are many challenges that we face during caregiving. Because when we started as a health professional, you are wondering, I'm a health worker, how do I go about telling patients about rights? Maybe something like writing a will, dividing property, power of attorney. It was not very easy. But when you have a passion for your work, it will work. It has worked with Nyeri Hospice from the beginning, and the number of clients and patients we are seeing, they are still increasing. The patients we are supporting on legal issues, the number is going up. It's not as when we started. So there are many challenges. Like when we started, even up to now, there are no policies put on policies on legal issues. We don't have any policies. We are just doing it based on the knowledge that we got. There are many other challenges, like when you receive a patient, sometimes you find that patients' rights are violated. Like a patient being denied rights of autonomy. You get relatives are the ones who are getting the information from the doctor or from the health care as a whole, but the patient does not know what they are suffering. Or when the investigations are done, sometimes patients are just left hanging. You are told maybe you have a growth, or go to hospice. That's the report we get. Go to hospice, they'll tell you everything. And in hospice like us, we are not the people who have done those investigations. It's the doctor and the nurses who are with the patients are the ones who get those investigation done. And they are supposed to disclose. Breaking bad news is also a great challenge, even in palliative care. Because patients come to us when they are diagnosed, they are made a diagnosis, but the disclosure is not done. So they are really suffering psychologically, socially they are suffering, because at times they are put aside. Relatives are called to be disclosed to their left hand. They are wondering, what am I suffering from that I cannot be told? And I'm not getting better even when I'm given medication. There are other challenges, like when investigations are done, and the patient is supposed to go through maybe a certain intervention like chemotherapy, radiotherapy, sometimes, or surgery, patients are taken in when even the doctor is aware that I'm taking this patient to theater, but he will not make it. The disease is in advanced stage. So it is really challenging for patients. When they come to us, they ask, I was told I'll be operated and I'll get better, and I'm not getting better. It is really a challenge to us, because for you to convince this patient, you have gone for surgery, and now telling the patient that now the condition is going down or you are dying is not very easy. Maybe after using a lot of resources, you get relatives selling all their properties to go through those expensive medications. Another thing, there's a great challenge in health fraternity, because like now we have very few people who are trained in this area. So even if you have a patient with you in a ward setup, it's not very easy for a health worker to talk about legal issues. They talk about lack of no knowledge, no skills, even to work on these cases. So it is very also difficult for healthcare workers to talk to patients about legal issues. Another thing, we need to advocate for legal issues to be put in place in each and every health facility or palliative care setup, so that people can be aware, the family members, they can be aware on how to tackle legal issues when they arise during care or even after, aftercare or during bereavement support time, they need to know how to go about that. The role of paralegals in palliative care is to support, give basic knowledge to patients and their families. We do not leave the family behind because they are the ones who are involved in caregiving at home. Especially when you are doing home-based care, the family members are the one with the patient all through in the care. Us, we just give support and we support them to take care, to give good care. Thank you.
I'll move back to the healthcare worker and the dilemmas that they face and ask Robert, from your experience, I know most of the issues that come your way is the dilemma on disclosure, which he has talked about. Who is entitled to know a patient's status? Can you help us understand that? Especially with laws such as, if I have developed AIDS or I have an HIV-related condition that is likely to result in death, and there are provisions and restrictions as to who can access that information based on the doctor-patient privilege.
Come across any law that is specifying who that information should be given to. But coming from what my brother has said, Article 28 of the Constitution, that provides that every person has the inherent dignity to have their privacy, and it is also buttressed under Article 31C of the Constitution that each person has the right to privacy, and especially to include the right not to have information relating to either family or private affairs unnecessarily required or revealed. Then that poses the dilemma, and I think it, from the onset, would be an issue of the stigma that is surrounding people who are suffering these life-threatening diseases and illnesses, that the moment you disclose the condition of a patient, then there is the potential for stigma. Therefore then, if you are to disclose information relating to a patient outside of their consent, then you may face challenges of why did you disclose that information to people that were not supposed to be given that information? And then it brings us therefore to the question, who should know the status of a patient, or assuming that by the time they are coming to the hospices or the other palliative care institutions, they already know. I'm assuming there are instances when they come without already having known the issue. So that you may have to disclose that information to the next of kin. I think rightfully, therefore we would say the person who must first get to know the condition is the caregiver, because it comes to them either by default, because they are there and they are attending the patient. Then who is the next person who must know? It is the patient. I think other than maybe instances of minors, young children who may not be able to digest the information or be able to hold the information, I think the first person who must get that information will be the patient. Next would be maybe the person who is supporting this person. If, for example, it is a man who is sick, I think disclosing that information to the wife would be in order. Or the person, for example, who is financing, because I've seen some of these issues relating to palliative care, they may relate to finances and so forth. But then I think that list, you must look at it very carefully, so that whether friends or employers For example, is an employer supposed to get the information only in instances where, for example, the work this person does would necessitate that the information be diverged. For example, if someone is working in an industry like here, where you just had lunch, maybe the employer may have to know the details of the sickness the person is suffering from. And only a few people, I think those who really are close to the patient should get to know. I think where maybe parents, a parent who is suffering, the children may be told in a way. I think we have seen out of experience that children also need to know so that they participate in that final process. So this person eventually may have to go to be the Lord, then the children will have to know what really happened. So I think you may share that information with only some people and not every other person because of the issue of being sued.
Robert, can a patient refuse care?
It is ironical in a way, because we are here because we want to relieve pain from people who are suffering from life-threatening illnesses. And I think the general principle is that, or the general rule about palliative care is that it focuses on relieving pain at the end of life, but does not help extend life. So that a patient, you may not really think of a patient who is refusing to be helped on their pain. But if it were to happen, and especially the issue of euthanasia, the Constitution is very clear, Article 26 of the Constitution. Every person has a right to life, and that article says actually that a person shall not be deprived of life intentionally, except to the extension that it is authorized by the Constitution. There are instances where the Constitution will say this person be killed. For example, they have also committed murder, or they have robbed with violence or treason, such. In such instances, the inherent right of to life, it may be curtailed. But there are instances where patients may refuse treatment, even because of issues relating to finances. And it could also be cultural beliefs. Grounds is not legal.
Before I open for questions, I would like to give about 3 minutes to one of our beneficiaries of the intervention at Nyeri Hospice to just explain from a personal, a patient perspective what the legal intervention program has had in her life.
I am Meritriza Kemuri, a teacher by profession, a victor of breast cancer, and somebody who have gone through the legal system. Let me start by saying I was diagnosed with breast cancer 04 on or around January. I went through the normal treatments at Kenyatta National Hospital. I was done mastectomy. I went through chemotherapy, and I also went through the radiotherapy. I also had to take tamoxifen for the next 5 years, which I never finished because of what you will maybe understand after a short while. Well, I went through the treatment, the whole treatment, but the problem was not even the treatment, it was not the doctors, but the problem was my husband. Because once he understood that I was diagnosed with cancer, I think he wanted to quicken my death. Though that one comes from God. Because I was tortured, I was oppressed, and when he saw that after all what he was doing, I was not moving out, he sent me out with the kids. During treatment at Kenyatta, he refused to support me financially, and he refused my people to help me, although they used to do it secretly. He was working for BAT. So Vic is a big company in Kenya and he was a manager. So he never lacked exactly he didn't want. And so when I left home with the kids, I had to settle them here at Nairobi. I have to continue educating them. I had to continue on my drugs. And that's why I could not continue on tamoxifen after the second year. I stopped there, but God is good, I'm healed. And so when we left the home, within 2 weeks, that's the time I discovered that he had sold a lot of property that we had acquired. With the lawyers, I had the fear. The lawyers were just too far away from my whatever. Again, I had this thing. I had too much on my plate. This was cancer. These were kids in the school. So my priority, I got it to be the kids. So I just kept quiet. I said, let it go. He can sell what he wants. And actually he sold practically everything. And so when Kenya came my way, before he came, I registered with a hospice, with another group of women who are also survivors like me. Ours is to spread awareness. We support them with the very sick patients, we talk to them, we encourage them. And so when we became friends of hospice, we started attending the legal clinics. For the first, the second, and the third, I look at my son, because he's the age of my sons, and I would say, now, what is this boy talking about? And then I would even say, surely, does he really know who my husband is? Because I knew for sure, after selling all the property, he raised about 5 million. And I knew he was the type of a person who could even hire that to come and kill me, because the cancer was unable to kill me. And so I was full of fear in myself. So I think after the 4th clinic of the legal, I went home and thought, now, even if I went through the legal system, what do I have to say? There is nothing. But my mind kept telling me, there is still the ancestral land, and that is their home and the home for my children. And so one night I thought, and then I saw, let me have a go at it. In any case, you confront your fears fearlessly and the fears go. So that's what I did. That's what I did. I took courage, I prayed God, and then I consulted a lawyer, another one, not him, another one, who told me, you don't need to go to the lands yourself. I'll go myself. Luckily I had a photocopy of our ancestral land. He went to the land and they put a caution on the land. And up to this day, that land is under caution. But at least on that one, I thank Kemunya, I salute the Nyeri Hospice, because at least I was able to save something. But as of now, at least I've come out of here. This thing will continue, not only for the victims of whatever disease, but to every woman and to every man, because even men are getting oppressed. Thank you very much.
I would like to share just a specific case. Lady, she is a lady, an elderly lady, who was referred to us as the Nyeri Hospice with an headache pain. And when assessment was done, we were able to manage pain, but it's all a matter of controlling, not at least managing it or dealing with it clearly. Little did we know, we were dealing with the physical pain where there was some other underlying pains. So when patient X was referred to us, it's when we came to understand she had some issues with the family members, and they were legal in nature, and we invited, because she could not come to our clinic, we invited one of the daughters to come and listen to one of the sessions in the legal aid clinic. And after that session, she told us how I wish that you could come home and at least give the same to my mother. And we made a point of making the same. and she confided on us, whatever I'm going to tell you, I don't want these children to hear, so can you tell them to go away, and you will remain the three of us in this house so that I can tell you what I want to say. This is when we came to learn that she had an issue with the rent. The rent they were sitting in was a family rent. Secondly, she had some accounts somewhere and she couldn't make a disclosure to that. And also there were some issues in terms of relationships with her family members. And we thought of the best kind of model and the best practice that we could use into resolving this issue. But may I bring up to the plenary that there are quite a number of interventions that we made, because as much as we were invited by this daughter of this lady, and she had told her mother the mission that we were coming for, she couldn't readily cooperate and disclose everything to us in the first instance. So that was a challenge to her, but we never lost heart. By the end of it all, the ladies have divided the lot. She disclosed where the accounts were, and she gave the power of attorney to members of the family, and the accounts were being managed by the family members. After we had done all that, then the patient rested in peace.
As I conclude, I'd like to open up for any questions.
I'm a palliative care nurse from Kenya. My questions, about 2 questions, goes to the lawyers. And I want to inform them about the ethical dilemmas that are faced by health workers when it comes to taking care of these patients with life-limiting illnesses, especially HIV and AIDS. Now, when it comes to disclosure of the unauthorized, to the unauthorized persons regarding the patient's diagnosis, this one comes really as a real ethical dilemma to the health workers, because you expect this patient to be taken care of by carers. They may be medical carers or they may be informal carers at home, and they do not know where the patient is suffering from. The patient may be bedridden, they're incontinent of stool and urine, and they are supposed to take care of this patient whom they do not know the diagnosis. How do they go about that? On the other hand, the patient requires emotional, psychological, and social support. The fact that they have a life-limiting illnesses, they need all this type of support. And the family or even the carers will not be able to give this support if they do not know where the patient is suffering from. The other question is on the pain control. Somebody talked about negligence. The medical worker can be sued because of negligence, because of not controlling the pain. We know very well that pain drugs, and somebody said here that they are classified as narcotics, and they are supposed to be ordered by a pharmacist, if it's from the manufacturer, and then prescribed by the doctor, and then administered by the nurse. So, on the part of negligence, who is going to be pinned down because of negligence? Is it the pharmacist who has refused to order the morphine? Is it the doctor who is not prescribing? Or is it the nurse who is supposed to administer the drug? Thank you.
Disclosure is not necessarily criminal. I think the only thing we're trying to say is that the caregiver must be very careful, that the disclosure should not be careless, so that it ends up, the information ends up with persons who need them not with the information and who may end up stigmatizing the patient. But if they are the persons who are taking care of this person, making decisions for them, for example, they are choosing to make these decisions, there is nothing criminal in the disclosure. I think the only key point is that care needs to be taken.